Good morning, everyone. We are here at 9 o'clock in council chambers for the hearing examiner hearings. Today's Tuesday, October 3rd, 2023. I'm calling the hearings to order at this time. Before we start the actual hearings, I'd like to make a few preliminary comments. Introducing our process. In our process, which is a little bit different than what is followed in other jurisdictions, the clerk will read the introduction to the case and swear in anyone who is testifying. City staff will then testify regarding compliance with public notice. The applicant will go first, present their entire case. City staff will go second and present their entire case. Excuse me. Public comment comes next. If you're here for public comment, please make your comments comprehensive, because once public comment is closed, it will not be reopened. Following the closure of public comment, the applicant will respond to questions and make any final comments. The staff will do the same, and then the hearing is concluded. If you have a cell phone with you today, please silence it or turn it off if possible, and take any cell phone conversations outside the room if you can. If you wish to have private conversations, please move away from the speaker's lectern, because it is very sensitive and we do not wish to record your private conversations. However, if your private conversation is recorded, it becomes public record at that time. Please come to the microphone if you have comments. No comments will be acknowledged from your seat. So if you do have comments, please come to the microphone so your testimony can be recorded. All testimony must be under oath. Members of the public, if any, are requested to go to the microphone at my left, your right. And the reason for that is to give the applicant and staff the ability to utilize the other microphone without issues. Not that we have issues, because we don't, hopefully, ever. Anyway, the microphone and podium to my left has the same full video and audio capability as the other one. Anyone who provides testimony other than the applicant and staff is requested to fill out a public participation card so that we may properly spell your name. If you do give us your email address, if you wish to receive a copy of the hearing examiner's hearing recommendation or order, as the case may be, please do so. However, please remember that once you do turn over your email address, it becomes public record and accessible to anyone from the public. With those preliminary comments, I'm going to turn it over to our very capable clerk to call the first case. Thank you.
Case number RZN 23-000010, address 550 Northeast 4th Terrace, applicant Big Marlin Properties LLC. The request is rezones lots 1 through 30 in block 2378, Unit 35 from single-family residential R1 to commercial corridor CC. The site is located between 550 to 716 Northeast 4th Terrace. If approved, the new zoning would be consistent with the Pine Island Road District PIRD future land use classification, allowing the properties to be developed. Any persons giving testimony today, if you are able, please stand and raise your right hand. Do you solemnly swear or affirm to tell the whole truth and nothing but the truth?
I do.
Thank you.
Thank you, Madam Clerk. Good morning, Mr. Heller.
Good morning, Madam Hearing Examiner. Justin Heller, Senior Planner with the Cape Coral Planning Division. I want to put in the record that this case was noticed with a sign placed on the property, ad run in the local newspaper, and letters sent out to properties within 500 feet.
Thank you. I will find the proper notice was given.
Thank you.
Thank you. May we have the applicant's representative up, please? Thank you. Good morning, sir.
Good morning. Let me give good morning, Madam Hearing Examiner Dalton. My name is Tom Slaughter with Cape Land, and I've been sworn. With me today is also Max Forya, Forya Planning. He's also been sworn. We've had an opportunity to present a client report that was reviewed by staff, and then as a result of that, staff prepared a staff report which we are in full agreement with. So based on that and the fact that there's nobody here from the public, under the hearing examiner process, number 4, the applicant may waive the applicant's right to an evidentiary hearing if the applicant agrees with the staff recommendation. So in this particular case, we do, and I have nothing further to add to it. So with that, are there any questions or Do you have any comments from your perspective? Because one of the things we've done was we tried to bring these properties into compliance for some time, a couple different ways. But in this particular case, there is only one zoning classification that will implement the future land use. So with that, we're good with it.
There is a member of the public who's here today. I have no idea what that person's, what they're here for. So with that understanding, if you wish to have a presentation today, that's fine.
Yes, ma'am.
But I do not know if the member of the public is here for this case or another case, and it would not be proper to ask that person.
Well, I didn't see that anyone stand.
I understand that, but it's really, let's see how things go. Do you wish to incorporate the staff report into your presentation?
Yes, we'd like to incorporate the staff report as well as the client report that were both included in this agenda packet in full, and include that as part of the record for city council consideration. My understanding, they'll do a pre-hearing and then set the final agenda probably later next month.
Well, city council is outside of my jurisdiction, but I'm assuming what you're saying is you'd like to have that presented to me for my consideration, so I will do so.
Yes,
All
ma'am.
right, okay. I have no questions, thank you.
Thank you.
All right, Mr. Heller, thank you.
Good morning again. Justin Heller, Senior Planner, the Cape Coral Planning Division. This is rezone 2310. And this is a rezone from R1 to commercial corridor. The rezone is approximate locations are 550 through 716 Northeast 4th Terrace. This is lots 1 through 30 in block 2378. So the rezone is about 14 parcels. They total approximately 3.64 acres. The applicants have 51% or more control of the land area, which per section 3.4.683 allows them to, I guess, include the whole block for their case for a rezone. The current R1 zoning of these parcels is inconsistent with the Pine Island Road District future land use classification, and the applicants wish to amend the zoning to commercial corridor to bring the zoning into consistency with the Pine Island Road District future land use classification so that the owners may develop these properties. Here's a current aerial, just highlighting in blue here the subject properties. And on my left, we have the current zoning map showing R1. We have commercial corridor to the south, east, and west, and more single family to the north. And then on my right, we have the proposed zoning map showing what it would be like once those parcels were changed to commercial corridor. So we analyze this under section 3.4.6. First standard, whether the proposed zoning district is consistent with the city comprehensive plan, and we find that it's consistent with policy 1.15. The proposed CC zoning is consistent with the Pine Island Road District future land use classification. We also find it's consistent with policy 1.15I. This is the commercial corridor criteria. We find the site meets 2 of the standards per this policy and at least partially meets 1 additional.
And my understanding, if I may interrupt you, Mr. Heller, I apologize. My understanding is that these standards are not mandatory. All the standards are not mandatory. They're more analysis than mandatory. Is that
Correct,
your
yes.
understanding? Thank you.
All right, so standard 2, whether the full range of uses allowed in the proposed zoning district will be compatible with existing uses in the area under consideration. Surrounding uses are single-family homes, apartments, and a restaurant. Let's see. So basically, we find that the full range of uses in the proposed zoning district would be compatible with the surrounding uses in the area. Standard 3, we find the full range of uses will likely be equal or less intense than the potential uses allowed in the surrounding proposed CC zone parcels. The smaller parcels will prohibit some of the larger, more intense uses. Standard 4, the rezone will bring the zoning into consistency with the Pine Island Road District future land use classification, allowing the development to occur on these sites. The CC district also allows a wide range of uses that could bring businesses into the area, that could bring jobs and services to the surrounding community. Standard 5, there's already some signs of assemblage in this block. There's also opportunity for additional future assemblage. There's additional CC zone parcels to the east, west, and south. The area is serviced by potable water, sewer, and irrigation. So staff does find that the site is suitable for the majority of uses in the commercial corridor district. And lastly, standard 6, we find that the commercial corridor zoning district is the only district that is consistent with the Pine Island Road District future land use classification. And staff's recommendation is for approval of the CC zoning, and we have not received any correspondence pertaining to the case. So I'll stand by for questions.
Thank you. I have no questions. Are there any members of the public who wish to provide input or testimony? Okay, seeing none, I'll close the public participation section of the public hearing, bring it back to the applicant's representative. Thank you. Can we have the applicant's representative up, please? Thank you. Come on up.
I'm sorry.
You can't hear me?
No, ma'am.
Okay. I can
Could you repeat that, please?
Yes, I said, can we have the applicant's representative up to the podium, which you're here. So good job. So do you have any further testimony or anything you'd care to present at this time?
None.
And just for the record, I think that what has just happened is a little bit different than what you have asked for in the beginning of the hearing. We actually have had the evidentiary hearing, so we have not waived the evidentiary hearing. I think what your initial request was to not be required to do a full presentation, but rather to incorporate the staff report and your own materials into a presentation today. So I think it's a little bit different than what you had originally said. I think we get to the same place, and our Assistant City Attorney wants to weigh in on this.
Hi, John McClario, Assistant City Attorney. Just wanted to point out for the record that the code in 3.1.11 in Land Development Code does require the waiving of the evidentiary hearing. However,
That doesn't
it's
allow for
just waiving of the document, the submission of testimony and evidence, but
Right.
a public hearing is still required under the code.
Thank you, I appreciate that. So just so we clear up the record, this has been an evidentiary hearing. You've chosen to submit on materials, which is fine. I think we get probably to the same place. It's just I want to make sure the process is clear if anybody else is interested in watching what's going on today.
Thank you.
Thank you. All right. Anything else, Mr. Heller? Okay, so I will recommend that the request be granted as made based upon the staff recommendation, based upon my review of materials and based upon the presentations this morning. I will attempt to get the recommendation out as soon as possible. As I like to say, time is money, and I would certainly like to have this part of your process move forward as quickly as possible. So Closing the hearing with those comments. Thank you, everyone. Madam Clerk, could we have our second hearing, please? Thank you.
Case number RZN 23-000006, address 3130 Freedom Acres East, 3018 and 3040 Freedom Acres West. Applicant, Development Services Planning. The City of Cape Coral is requesting a rezoning of 3 parcels in northwest section addressed as 3130 Freedom Acres East, 3018 Freedom Acres West, and 3040 Freedom Acres West. The amendment would change the current zoning from R1 Single Family Residential District to the RE Residential Estate District. The applicant is requesting this change to align the zoning district with the future land use mapping and create legal conforming lots. The 3 parcels measure approximately 538,626 square feet or 12.37 acres and would not change the zoning classifications of adjacent properties. Any persons giving testimony today, if you are able, please stand and raise your right hand. Do you solemnly swear or affirm to tell the whole truth and nothing but the truth?
I do.
Thank you.
Thank you, Madam Clerk. Good morning, sir.
Morning, Madam Hearing Examiner. For the record, Anthony Santor, Associate Planner, Cape Coral Development Services, City Planning. The case was noticed with a ad in the paper of record. We did mail notices to all residents within 500 feet of the subject properties, and we did post signs on the properties for notice of the hearing date and time.
Thank you. I will find that proper notice was given. Did you hear at all from the properties which were the subject of this rezoning?
We did, Madam Hearing Examiner, and with your permission, I will get into it in the presentation, and we'll go over the correspondence I had with one of the property owners.
Super, thank you. I think this is the first time we've had a residential estate zoning matter, at least I can recall. That's interesting.
The first one I'm aware of.
Well, it's always interesting to plow new ground. How appropriate in a residential estate zoning case. Go ahead, thank you.
So since the city is the applicant, I'll be presenting. Again, for the record, Anthony Santora, Associate Planner for Cape Coral Development Services. My credentials are on file with the City Clerk's Office. I'm here today to talk about RZN 23-00006.
Do you wish to be considered an expert for purposes of this hearing?
If it pleases Your Honor.
Okay, based upon your CV, which is on record with the clerk, and based upon your testimony in other cases that are somewhat similar to this one, I will find you as an expert in land planning issues today. Thank you.
Thank you. So as stated, the applicant is the City of Cape Coral. The property owners, there are individual property owners for each individual property. The addresses are 3130 Freedom Acres East, 3018 and 3040 Freedom Acres West. They're just north of Northwest 29th Terrace in the Northwest Cape. They're approximately, when combined, 12.37 acres, although they do not share adjacent property lines. And they are in the Urban Services Reserve area. So the city is requesting a small-scale rezoning from single-family R1 district to the residential estate district for these 3 parcels. So they are currently developed with single-family residential dwellings. For the zoning history of the property, they were public facility until about 1992 or 3, at which point they were converted to R1A. From there, they were converted from R1A to the R1 district in 2019 as part of a large-scale map amendment from the city when the R1A district was subsumed into the R1 district. For the future land use, originally the area in the northwest portion of the Cape was classified as public facility. It was the designation land for the municipal airport at one time. That never happened. So in 2010, the public facilities designation was shifted from public facilities to LDR, low density residential. So this current rezoning request is to remove the current inconsistency that exists between the future land use classification and the zoning district classification, as the LDR, the low density residential land use, does not permit the R1 district within it. So here we can see a map of the 3 parcels. You can see 2 of the parcels here in the lower left and 1 parcel farther up here. What you'll see in the next picture is the current zoning of the properties, and the 3 properties highlighted are all R1. The surrounding properties are agricultural, and the properties to the south of it are residential R1 properties as well. Something to note here, the properties shown in the agricultural, that is the designation limit of the LDR zoning class, or LDR land use classification. When the properties were converted, the surrounding areas were converted to agricultural, but these 3 properties were highlighted for R1A classification. Staff couldn't make a determination why that was, but it was very clearly highlighted that those 3 properties were converted to R1A as opposed to agricultural like its surrounding counterparts. So the request today is to take these 3 parcels to one that is agreeable with the land use classification, that is the residential estate. So to that end, we analyzed the code requirements, and specifically section 3.4.6.b, and we looked at the first criteria, whether the proposed zoning district is consistent with the city's comprehensive plan. In short, it is, and we'll get into the specific policies that it is in agreement with and a little bit further into the presentation. We also examined criteria 2, whether the full range of uses allowed in the proposed zoning district will be compatible with the existing uses in the area under consideration. The adjacent area, there's some moderate development, and it mainly consists of single-family residential homes, given the rural agrarian nature in the R1 districts that it shares a border with to the south. The RE district has uses that are generally compatible with single-family residential uses. It shares a lot of these same setbacks, height classifications, density requirements that the residential properties have. It also shares a lot of similarities with the agricultural district, minus some of the more commercial uses that are permissible within the agricultural uses, along with some restrictions, more restrictive items when it comes to some agrarian uses like horse stables and outbuildings and things like that. So what we found was that the proposed zoning district of RE is consistent with that criteria. We also examined criteria 3, whether the range of uses allowed in the proposed zoning district will be compatible with the existing potential uses in the area under consideration. As I had stated, that the RE district is primarily a low density and low intensity district, sharing a lot of these same uses, same densities, same requirements as the R1 and agricultural districts, which immediately surround the property. So we found that the proposed RE district would be consistent with this criteria. We also examined whether the proposed zoning district will serve a community need or broader public purpose. This rezone will bring these properties into conformity with the Land Development Code, and it will allow for redevelopment or any issues that had arisen from a inconsistency, such as pulling of permits, which were not able to be done before due to certain issues of the inconsistency, to be resolved. So we found that this is in the community's interest in serving a broader public purpose, and so therefore it was consistent with that criteria. We also examined criteria number 5, whether the characteristics of the proposed rezone area are suitable for the uses permitted in the proposed zoning district. So the site is 3 parcels for roughly 12 acres. It does sit along 2 local roadways. Both of them are unpaved in that area. They do have 2 separate roadways, both of them being local. The lots are generally rectilinear. They do contain, at minimum, each lot 100,000 square feet. There's minimum topography and some varied vegetation. The larger property does have some wooded areas behind it when it was combined with a lot adjacent behind it. They do meet the minimum requirements of the RE district, and so what we found was that the proposed rezone area is consistent and suitable, and that the request is consistent with this criteria. We also examined criteria number 6, whether a zoning district other than the district requested will create fewer potential adverse impacts to existing uses in the surrounding area. So currently in our comprehensive plan, the LDR future land use classification does permit 2 zoning districts, that being the residential estate, the RE district, which we're requesting, and the agricultural district. However, with modifications to the comprehensive plan that were made in the past couple years. We no longer rezone to agricultural. It is only existing agricultural to remain. So there is only one permissible zoning district that we can rezone to, which would fit this criteria, that being the residential estate district. So given that there is no other zoning district which would be permissible or more appropriate, and therefore we found that the rezone would be consistent with this criteria.
Since you've been classified as an expert, I'm going to ask you to speculate on a question. Why do you think that the city does not permit rezoning to agricultural at this time? If you know, and I realize you may not.
I really couldn't say. It was taken, it was done before I got here. So I couldn't really speak to it. I could only speak to some generalities, and would mainly, in my opinion, would be towards shifting development in the Cape, where we're seeing a lot more single-family development, a lot more commercial development, a lot more infill development. The more rural areas are being developed, where you're losing some of the rural agrarian areas. That would be my opinion. Again, I couldn't really specify without going back and doing a little bit more deep dive onto it and reading the ordinances and talking through staff on
No
to why
worries.
it was.
No worries, not needed. I know you're swamped with work. It was just curiosity on my part. Thank you.
So as part of the analysis, we did review the comprehensive plan, and what we found was that the proposed zoning district is consistent with goal of Chapter 4, Policy 1.15, and that being that the proposed zoning district is consistent with the LDR classification, that the lot achieves a density consistent with one dwelling per 40,000 square feet, and that the other permissible zoning district, agricultural, is limited to existing only. So based upon all of that, we found that it was consistent with that criterion. We also analyzed the city fire and impact, police fire and impact, of the potential redevelopment. What we found from fire was that the properties are currently served by Fire Station 15. They're expecting any minor impact, if it does occur, for any types of future development
Fire
based.
Station 7, but okay.
Oh, I'm sorry, Fire Station, I was
That's
looking
okay.
one down. My apologies. Yes, Fire Station number 7, they were estimating a full development of the RE capabilities, generating less than 15 calls annually with minor impact to the department. Likewise, for the police, the property is served by Police Beat Zone District, North District Zone 3. The proposed development would have no impact on service demands, and there were no other additional concerns that they had. So given this, city staff is recommending approval of the rezone. Prior to this meeting, staff did speak with the property owner of 3040 Freedom Acres West. When speaking with the property owner, they did specify that they had conversations with the neighbors, and that the neighbors, the other property owners, I should be more specific, would like to see the property rezoned as agricultural to match the surrounding areas and what they were told when they originally bought the properties, that it was agricultural in nature. After some talks with them and explaining the RE district, he didn't necessarily have an issue with the RE district per se. He did have an issue with some of those more stringent requirements, specifically towards outbuilding setbacks for horse stables and sheds and things like that. But he did not necessarily have an objection to the RE district, as long as there were possibilities such as possibly seeking a variance or something of that nature, if he did wish to in the future construct one of those out parcel buildings on his property.
And as you've just articulated, it's not possible to rezone to the agricultural, so.
Correct. I did explain that the properties were never zoned agricultural, and that we could not take it to the agricultural zoning because the comprehensive plan prohibited us from actually rezoning properties as agricultural now. So he understood that, and he thanked me, and that was the end of the correspondence.
Okay, thank you very much.
And I'll stand by for any questions.
No questions, thank you. This is a public hearing. Are there any members of the public who wish to provide input or testimony? I don't see anyone leaping to the floor, so I'm assuming that's no. So we'll close the public comment section of the public hearing, bring it back to Mr. Santora. Nice presentation, sir. And anything else you'd like to say?
Nothing further at this time.
Okay, thank you very much. I will recommend that the zoning go forward as requested, the rezoning, excuse me, go forward as requested. And I'll try to get the recommendation out as quickly as possible.
Thank you.
Thank you very much. Closing hearing number 2. Madam Clerk, thank you.
Case number RZN 23-000009, address 1917 Southwest Santa Barbara Place, applicant Cape Life LLC. RZN 23-000009 is a privately initiated rezone for 0.57 acres, one parcel, located off of Southwest Santa Barbara Place. The request is to rezone these properties from Commercial C to Residential Multifamily Low, RML. The property is undeveloped. The applicant intends to build multifamily residential at this site. The future land use is multifamily residential, MF, which was amended earlier this year. RML zoning is compatible with the MF future land use. Approximately 0.57 acres of commercially zoned land would be lost if the application is approved, though the request would bring the property into conformance with the future land use. The site could develop a maximum of 9 multifamily residential units. Any persons giving testimony today, if you are able, please stand and raise your right hand. Do you solemnly swear or affirm to tell the whole truth and nothing but the truth?
I do.
Thank you, Madam Clerk. Good morning, Mr. Boyko.
Good morning, Madam Hearing Examiner. Before the applicant comes up and testifies as to the case, I would like to note that this case has been properly advertised. There were letters sent out to residents within 500 feet. There was a sign posted on the property, and there was also an ad placed in the newspaper of local circulation. And all of this was done prior to the 10-day window before this hearing.
Thank you. I will find that proper notice was given. Thank you. Mr. Mazurkowitz, good morning, sir.
Morning, Madam Hearing Examiner. Joe Mazurkowitz, President of BJM Consulting, here on behalf of the owner of the property, Cape Life LLC. Madam Hearing Examiner, based on my previous submitted CV and previous testimony in this venue, I would request to be an expert witness.
I will find you as an expert witness based upon your credentials, which you have submitted prior to this date, and also based upon your testimony regarding matters that are similar to the issues presented by this hearing. Thank you.
Thank you, Madam Hearing Examiner. This case is just a little bit unique because we came back in after the, you will hear in the city's presentation, the city initiated a land use change from multifamily to commercial, and it did it in a citywide fashion to where the individual owners were not aware of it. This individual owner, after that change occurred, spent years trying to market the parcel as commercial, but the fact that it is surrounded by 7 multifamily units, and has no frontage on a 4-lane arterial. He selected to move forward with a land use change going back to multifamily. Problem being, its uniqueness of going as an individual and not taking everyone collectively, it almost becomes a spot land use, if you will, and then a spot
Singing my
zoning.
song, Mr. Mazurkowitz, that's exactly my first question. Thank you.
So what we did, because we didn't have the applicant's of the approval of the adjoining properties to go through with this thing, we went through ourselves and presented to the city of Cape Coral the facts at the land use change, and the city of Cape Coral City Council asked me, on behalf of the owner, to go ahead and contact the surrounding property owners, which we did, and we had letters from 4 of the 7 developed multifamily properties saying that they wish to go back to multifamily. Interestingly enough, at Ian, a lot of them lost their roofs, and they were redoing new roofs at the time. And my concern was, at that point, when your land use and zoning don't match, insurance claims occur, you need to get new insurance. You don't buy insurance if your land use and zoning doesn't match. So the city council directed staff to go ahead as a follow-up to this to move the rest of the northern end of this block, 3100, to multifamily. So with that as a little explanation as to why this spot land use, spot zoning is occurring, I want to go through the facts of the case. This site is 25,000 square foot with 200 foot of frontage and 125 foot deep. Is currently serviced by all 3 utilities, about 0.57 acres on Southwest Santa Barbara Place. We're requesting the zoning change of the entire site from the existing commercial to RML, multifamily 16 units per acre. The parcel is towards the center of Block 3100, whose northern area is highly developed with 7 multifamily units. Many of these buildings are 2-story multifamily units and some duplexes. Currently, the entire block, except for this parcel, has a CP land use and is zoned commercial. Because of the intense development of the northern end of the block already being multifamily, it was discussed, as I said earlier, at our land use meeting, that staff would change the northern end of this block to multifamily use and zoning, with the consent of the majority of the owners in the area. The location of the parcel, surrounded on 3 sides by existing substantial multifamily units and single-family across the street to the west, makes the multifamily zoning the best opportunity for development both near and long-term for this site. In reviewing the application with the reviewed required criteria, the proposed RML zoning is consistent with the property's multifamily land use. It's smaller than the required 1 acre necessary for RMM, so the only zoning allowed by the code is RML. The full range of uses in RML zoning are compatible with the existing potential uses in the surrounding area. The location of this parcel makes it a great site for workforce housing, making the use allowed for the rezoning compatible and an asset to the existing potential uses in the area. The requested RML zoning will serve the community need to provide attainable workforce housing right next to employers within the Santa Barbara Boulevard corridor. The requested RML zoning will allow for the development that fits well within the characteristics of the area and the residential area to the west. And there's no other zoning district allowed in the multifamily land use that will create fewer impacts to the surrounding area other than the allowed zoning, which is RML. RMM is not permitted as the size of the parcel does not meet the 1 acre requirement. Based on the submitting information in our package, we also have reviewed the staff report, agree with it, and would ask it would be included in our presentation. We would ask for your favorable recommendation for the zoning change.
Thank you, Mr. Mazurkos. I have no other questions. Thank you. I have no other questions. Thank you. All right, Mr. Boyka, thank you. And I know you're filling in for Mr. Daltrey, so I appreciate you doing that. Thank you.
No worries. Before we begin, I would like to be recognized as an expert witness based upon my credentials obtainable with the City Clerk's Office and also my previous testimony before you in the matters of land use and zoning.
I will find you as an expert based upon your CV, which is on record with the clerk's office, also based upon your very extensive testimony on matters similar to those today, and also based upon your magnificent job in rezoning the entire city, along with the very able assistance of Mr. Daltrey and staff.
All right, so before, what we have here before you is RZN 23-9. This is a privately initiated rezoning from commercial to residential multifamily low, or RML. It is for 0.57 acres within a site that has an address of 1917 Southwest Santa Barbara Place. It's 4 lots within Block 3100. The applicant is Cape Life LLC, and we mentioned that they're asking to go from the C zoning to the RML zoning. The site's mostly in the center portion of the city, located along Southwest Santa Barbara Boulevard. Here you have an aerial and a current future land use map. The aerial, as you can see, it's on the back half of a block with frontage on Santa Barbara Boulevard. And as you can see that it is mostly surrounded by residential development. I believe to the west across Santa Barbara, you do have some commercial development that's there, but those properties do have frontage that is along Santa Barbara Boulevard, whereas this site does not have any direct frontage along Santa Barbara Boulevard. The surrounding land use of all the properties within this site is the CP, or the commercial professional land use. That exists also a little bit to the south, but you also have a scattering of land use classifications to the north and to the south, where you have a combination of multifamily or single family, and then to the east across a local street, you have single family residential zoning.
So the residential zoning, could you go back one? The residential zoning that is illustrated on this map makes all of these multifamily or single family, whatever, I think they're multifamily though, properties non-conforming.
The commercial professional land use does make that non-conforming, yes, if they are residential developed properties.
Right, I understand, thank you.
So the current zoning, as you can see, is the commercial zoning, which is the C zoning, which is replicated throughout the entirety of this block. To the east across that street, you have the single-family residential zoning. To the north, you have that same split where you have multifamily zoning on the back half of a block and then commercial zoning on the front. And that same pattern is somewhat replicated to the south, where you have commercial with the frontage on Santa Barbara Boulevard, and then a little bit of single family on the back half of that block. And then the applicant's request is they're taking this site to that RML multifamily low zoning. The history, the subject property along with the entirety of Block 3100 was amended to the CP land use back in 2010. This was part of a large-scale attempt by city planning staff to get as much land into a non-residential land use classification as possible, because at that time we were faced with a constitutional amendment which would have required any land use and I believe zoning change to go before a public referendum. So there was a large push to gather as much property as we could, thinking that it would be extremely challenging to do any land use or zoning changes if that public referendum law would have been passed at the state level. So we were far-reaching in our attempts to grab as much non-residential land as we could. The block was also rezoned to commercial back in 2011. That was sort of the follow-up to the land use changes that we had done. At the time, the block was developed with multifamily uses for approximately half of the block or so. However, since those changes had occurred back in 2010, there has not been any commercial development within this block that has occurred over the past decade or so. And then kind of following up with that, you saw that the subject area was amended to the multifamily future land use earlier this year as part of Ordinance 52-22. Some more history. When the future land use map amendment was adopted earlier this year, additional properties were identified as potential or future properties that could have the multifamily future land use designation on them for an upcoming amendment. That amendment has not yet occurred. However, there is intention by city staff to amend more properties within Block 3100 to the multifamily residential land use classification. And that would sort of remove some of that spot land use, spot zoning nature that is occasionally can be a tricky situation with properties like this. So the rezone has been analyzed per the comprehensive plan and the land development code. The proposed zoning is supported by policy 8.5 of the future land use element, which discusses transitional uses between higher and lower intensity development. If you were to have commercial that was developed along the frontage of Santa Barbara Boulevard, and then you had some transition from commercial to multifamily to that single family land use and zoning that is on the east side of this site, you would have that sort of step down effect that is a long-term sort of planning idea, is to and de-intensify uses as you go towards single family, and that would occur in this situation. Also, the site was recently amended to the multifamily future land use by City Council, and then a rezone was designed to make the site consistent so that you would have the site sort of have consistency between the land use and the zoning. So then the rezone was analyzed per section 3.46 of the Land Development Code, which provides 6 standards for rezones that we look at cases by. The first standard is whether the proposed zoning is consistent with the city's comprehensive plan, and the proposed zoning of RML would be consistent with that multifamily future land use designation. The second standard is whether the full range of uses allowed in the proposed zoning district would be compatible with existing uses in the area under consideration. We've made mention that the majority of the surrounding uses of the site are residential in nature and are either duplexes or multifamily housing. The uses that are allowed in the RML district, therefore, which are residential in nature, which allow for single, multi, or duplex development, would be naturally consistent and compatible with those uses that are currently existing within this area. The third standard is whether the range of uses allowed in the proposed district would be compatible with the existing and potential uses in the area under consideration. We mentioned earlier that the uses in the RML district would be compatible with the existing residential uses. The other properties in the block, they could develop with the CP land use. That being said, with the multifamily and the commercial, sometimes they work hand in hand. Sometimes there's some challenges with those two uses. But that being said, city staff does have the intention to change more properties within this block to the multifamily future land use, and then subsequently to the RML or the RMM district based upon the desires of sort of the owners that are in that area. So staff finds that at the current time, you may have some challenges with some compatibility between commercial and multifamily uses. In the future, you'll have those lessened by the fact that there is the intention to have more of this block go to the multifamily land use and zoning classifications. Standard number 4 is whether the proposed district will serve a community need or broader public purpose. The city has identified a need for increasing multifamily housing within Cape Coral, and the proposed rezone may assist in a small way in addressing this need. It doesn't add a lot of land to the RML district, but it does add about half an acre, which does add some additional multifamily units in an area that already has existing residential dwelling units. The 5th standard is whether the characteristics of the proposed rezone will be suitable for the uses permitted in the proposed zoning district. The area meets the minimum lot requirement of 10,000 square feet for the RML district. The size of the site is suitable for most of those uses in the RML district. The site does not, and this kind of goes into the next one with whether a district other than the proposed district requested will create fewer adverse impacts. The site would not qualify for the RMM district, which is why it wasn't specified here. You do have to have a minimum of 1 acre in size for the RMM district, and consequently the RML is the most compatible zoning district that goes along with this future land use classification. Staff's conclusion and recommendation: the proposed rezone would complete the formal change of use for this site from a commercial site to a residential site, and the rezone would make the property's land use and zoning consistent and would permit development of the site with either single, multifamily, or duplex uses, and staff recommends approval of the proposed rezoning request.
In your expert opinion, given all the complexities that have been brought forward by yourself and by the applicant's representative, does this constitute spot zoning?
I don't believe it does. I think if you were looking at this in the term of if you're introducing a multifamily use into a block that already had a lot of existing sort of commercial uses established over the years, that could have lent itself more to a spot zoning aspect. But I think with the fact that you have long-standing residential uses in this area, and there hasn't been any sort of inclination for this block to develop commercially. And also, too, additionally, you have single-family zoning that is located to the east, so you're not introducing a new zoning district, or land use category into an area that it doesn't have anything existing in that case. So I don't think it does constitute spot zoning or land use due to the existing nature of residential zoning to the east, and then also the existing residential uses that are on this site and in the nearby area.
Thank you. I have no other questions. This is a public hearing. Are there members of the public who wish to provide input or testimony? Seeing none, I'll bring it back to the applicant's representative, Mr. Mazurkowitz. Anything further, sir?
Madam Hearing Examiner, just one thing to support staff's presentation. The existing residential to the north and east of this property, as I alluded to earlier, went through some damage for Ian. They rebuilt. If they were going to develop as commercial, they wouldn't have rebuilt. They've just invested major capital improvements, putting new roofs on most of those buildings. So I don't see in the near term, the opportunity for commercial development being non-compatible next door. So I see that also adds some testimony to the fact that it's not land use is spot zoning. And further, Madam Hearing Examiner, we thank the staff for their presentation, and we would like to incorporate it into our support materials this morning.
Thank you very much. I appreciate that. Mr. Boyko, I don't think that you incorporated your staff report. At least I didn't notate that. Do you wish to do that at this time?
Yes, we would like to incorporate the city staff report into the presentation.
Anything else based upon Mr. Mazurkowitz's testimony or anything else?
Nope, we're good.
Okay, fine. Thank you very much. I will recommend that the request go forward. I will address the issue of spot zoning. I agree with the applicant's representative and staff that under the unique circumstances of this case, I don't believe it constitutes spot zoning, but I do appreciate the additional elucidation of factual information. So, and I know, as I've said before, time is money. I will attempt to get my recommendation out as quickly as possible. With those comments, I'm closing this hearing. And that concludes our cases for this morning. The date and time of the next hearing is Tuesday, October 17th, 2023, 9 a.m. here in Council Chambers. We stand adjourned at 9:49 a.m. Thank you.